public participation in a manner consistent with social distancing practices, the following procedures are in effect for the meeting. Members of the public may view the meeting on a live broadcast via the WebEx internet platform or via recording once available on the Commission's website and via YouTube. Remote testimony will be accepted on all items from persons virtually present to speak by video conference or by phone following opening remarks and administrative announcements. If you would like to present oral testimony remotely, please register through the WebEx internet platform. Written testimonies, including the testifier's address, email address, and phone number, will be available to the public on the Commission's website. As a courtesy, please turn off all cell phones for the duration of the meeting. Commission Aide George White, would you please call the roll to confirm the attendance of commissioners at this meeting and the presence of a quorum?
Yes, Chair. Chair Mould, present. Vice Chair Wong.
Present.
Thank you. Commissioner Bean. Excused for now, Chair. Commissioner Legal, I believe may be on a trip. Ask for him to be excused for now. Commissioner Peters.
Present.
Commissioner Pham.
Present.
And Commissioner Stormo Gibson. I know she's present virtually. Let's see. Commissioner Stormo Gibson, can you hear us? It looks as though she is unmuted. Commissioner Stormo Gibson, can you hear us?
Can people hear me?
Yeah, now we can. I can hear you. Okay.
I don't know if I can hear anyone else.
Okay, well,
I need to try
we have Commissioner Stormo Gibson's confirmation that she is present, so we can proceed with the meeting, and then Commissioner Stormo Gibson.
My phone because I just can't hear anything.
If you do what you need to do to adjust, and we can proceed slowly with the other matters. But Chair, you do have a quorum present.
Given the presence of a quorum, let us continue on with our agenda and the business of the Commission. Commissioners, pursuant to the Governor's proclamation, the meeting will automatically recess if we lose audio-visual contact with you and cannot reconvene until we reestablish contact. Therefore, please announce beforehand if you will be voluntarily signing out of the meeting. Members, I'm going to defer approval of the minutes of our December 20th, 2021 meeting until our next meeting in the new year. Commission Aide White wants to make sure the discussion points and comments from that meeting are accurately and adequately represented in writing. The video recording of that meeting is available on the Commission's website and via YouTube. We will now proceed to remote testifiers. To those coming in remotely, please video conference from a quiet location. Also be sure that your microphones and cameras are in working order. For those joining us by phone, we will identify you by your phone prefix. If technical issues arise, I will give you a few moments to try to resolve minor connection issues. However, if it cannot be resolved, I will have to move on to the next testifier. When I call your name, please state your full name and the agenda item or items you are testifying on. Speakers are limited to a 2-minute presentation on each item. When the timer goes off, please conclude your remarks promptly. I will close testimony once all remote speakers have testified. I see before me Ms. Carson, Ms. Ellen Carson. Do you have, we received your written testimony. Thank you very much. Do you have oral testimony you would like to give today?
I would. Can you hear me?
Yes.
Yes, thank you. My name is Ellen Godby Carson. I'm testifying on behalf of the Faith Action Housing Now group. And we are in strong support of the empty homes tax that the Commission has now placed into its interim report and initial recommendations. And we so appreciate the work that you folks have been doing and the bold courage with which you've faced a task of trying to look for changes that could serve our community better. I wanted to just spend my short time devoted really to why Faith Action is involved in this effort of supporting an empty homes tax. Faith Action is a group of over 20 organizations that are all nonprofits in the state, community organizations, faith-based organizations who seek to change some of the basic inequities that are hurting our communities so much. And one of those is the lack of affordable housing. And that is our focus in our efforts with the commission and with the council to try to get into place an empty homes tax of the nature that you have proposed. It's something that could help address the needs of our families, seniors, working people that are here. It's something that could help stop or diminish the speculation in land that's happening that takes our homes and puts them into some other use than residences. And it's something that could help by devoted revenues to go toward creating even more revenues for affordable housing and for addressing homelessness. There are two really major crises in our state that have not faced adequate solutions yet. And we believe that this is a very effective tool to help work in that direction. So thank you.
Thank you, Ms. Carson, for your testimony. Speaker Say, would you like to say anything today?
At this point, let me say at this point, we did talk to Ellen last week prior to Christmas, and what I tried to do was get a comparative analysis of the two bills plus the vacant home tax, and we're working at it also. And I think Melvia and I will be talking to OCS, and that would probably be out and long at this time. But I heard that there's another assignment going out, and so there may be another attorney supporting and assisting us. But thank you very much for considering the vacant home tax as a proposal for the council to consider.
Great. Thank you very much, Speaker Say. We appreciate your leadership on this issue and your consideration of this issue. We appreciate that very much. I see Janelle Denny. I believe she's on staff monitoring, but just to confirm.
Chief of staff for my office,
Yep.
along with
Yep.
Melvin also staff.
Great. Thank you very much. So there being no other testifiers, testimony is now closed. Thank you, members. If there are any questions, Ms. Carson, would you be available? Would you be able to stay on for a little while, or would you like us to ask any questions now if we have them?
I hope to be able to stay on the whole time, but I do have someone who said they were going to drop something by at 10:45, so I may need to go to my door for a short period of time at that time.
Okay.
So I'm here for any questions. Yes.
Are there any questions from the commissioners for our testifier today?
I do have one question, which is, I know I forwarded to the commissioners, and I've brought it up previously about how Maui County is pursuing a category for long-term renters, and that they have created this form where landlords have to submit documentation saying that they have a long-term renter in order to not pay a higher tax rate in the future. I think that's where Maui County is going. And I'm curious, Ms. Carson, what you think of that approach as compared to the Vancouver approach.
I think that simply focusing on the long-term renters is not as comprehensive approach as the Vancouver approach in terms of empty homes tax. And I'd be glad to send some additional analysis on that. I'm looking for something that I've done specifically on the Maui, thinking about the Maui bill. If I tell you what would be most efficient for your time is if I could just have a minute or two to reflect my notes on, review my notes on that and be able to respond.
Yeah.
We'd appreciate that. Yeah, thank you.
Also, I think I brought this up previously, and maybe we can do this at a future meeting. That's not in the holiday time, but I think it'd be great to get Martin from Maui County implementing this to maybe provide some thoughts. I know that December 31st is the Maui deadline for landlords to essentially show proof that they have a long-term renter. And, it might be interesting to see how that's going. And I believe Councilmember Kiani Rawlings, from Maui, was also very involved in that effort because she's chair of their budget committee.
I did have remarks. Thank you. I just needed to refresh my memory on the Maui ordinance. The Maui ordinance is providing a real estate property exemption for those who have certain types of long-term rentals. They need to be at least 12 months of a rental, 12 months under contract, or a continuing renewal of that type of thing. There's some major differences in that because what they will accomplish is a reduction in revenues to the county. Whereas what we're seeking, because we're imposing a supplemental tax as an empty homes tax, would be additional revenues. Because what Maui's doing is creating an additional exemption. An empty homes tax, by comparison, creates a supplemental tax. So you're looking in Maui at a reduction of revenues that'll come through that rather than an increase of revenues. So that's one item. The second is that because it's requiring a 12-month lease at a minimum, plus whatever extensions exist, year-by-year extensions, I believe. Part of what it's going to do is cause landlords to be much tighter about requiring at least a 1-year lease and then a 1-year renewal on that so that they won't have somebody that's just a month by month. Part of my personal concern about that, and I haven't discussed this with Faith Action, is just that would potentially create a situation where tenants become locked in by the terms of their contract to a term of years, or at least a year, whereas most tenants need a little bit more flexibility than that and typically would like to be just on a month-to-month after a 1 year so that they can have complete freedom of giving that 30-day notice in order to get out. What it might mean is that landlords would have greater actions against tenants and more control of tenants. Yes, that encourages the long-term rental that we're all seeking of having stability of housing. However, I don't think we want to do it in a manner that would unjustly tie the hands of renters who reasonably might need to move for a whole variety of reasons after they've been there for a while. So that was one concern. I think also that requiring a specific 12-month lease for rental payment is something that would not address the needs of our extended families, many of whom are in our ethnic communities where it's quite common for one family to own a couple houses maybe and rent. Allow the occupation of a second house by one of their extended family. That is technically not done in a rental aspect with a 12-month contract normally. And part of the way that we drafted our empty homes tax proposal, you'll notice, is not just to require 6 months rental, but also to allow a 6-month occupancy by someone who's a permitted occupier so that we can address that issue of extended families, which are fairly common in Hawaii, whether it's in an auxiliary dwelling unit or an ohana unit, as they used to be called, or different things. So that's one concern too, is that it may have an unintended negative consequence that way. It could be easily addressed, I think, within the marketplace by having some type of specific form created, perhaps with a government suggestion that would allow people to have a 1-year occupancy or 6-month occupancy without needing to have a rental fee associated with it and without needing to have excise tax because there would be no rental. So that's one of the issues. So I think those are the major ones to me. A drop in revenues instead of potential increase in revenues, this unintended consequence to community extended family type thing, and then a situation in which tenants would have less flexibility and landlords would have greater control. And the question is whether those types of unintended consequences are okay compared to the added benefit to Maui of having and encouraging more long-term rentals, which is what the goal is. I guess my personal concern would be one of looking at those unintended consequences and saying, can we tweak this bill in a way that will, at least for those latter two issues, not the revenue issue, but for the other two, could help be able to address those.
Thank you for that analysis. That was actually very helpful. I believe for the first part, the intention is actually to increase revenue by increasing tax on everyone who does not fall into the long-term renter category. So
which
for
has
now,
not been done yet. Okay. Yes. If that is the intent, yes. Okay.
that is the starting next year. The
Okay.
thing to avoid increasing taxes on people who do have long-term renters, they first wanted to verify and create that category, right?
Yes.
But
Okay.
yeah.
That is the tweak then that would permit positive revenues instead of negative revenues for the county, which is presumably what they would like.
Yeah, Maui County is trying to do similar to what Honolulu needs, which is raise money from homes or homes that are not long-term renters to pay for the housing they need. That is the
right.
And so this was just a step on that process. But I also appreciate the complexities you brought into around, you know, after 12 months, for a month to month, or how does that work? And also, like you pointed out, people that occupy but might formal lease agreements, how does that get resolved? So
right.
important to think through.
I would be glad to send you further info on that analysis, but again, it is my personal analysis and hasn't been vetted through Faith Action. Okay.
Vice Chair Wong here. I've got a question for Ms. Carson. When we talk about the unintended consequences of this bill, one of my main concerns is that it imposes a de facto documentation requirement for all residential landlords because of the need to comply with the declaration and because of the need to provide substantiation upon request by the city. Even if tenants are in a residential property, and even if landlords are renting that property out, the cost of complying with this are still going to fall upon the landlords. And I think that it's logical to say that those will be passed on by landlords to those tenants. Has there been any consideration that those compliance costs might actually raise rental prices because of the cost of compliance imposed on landlords?
Landlords are already required to keep documentation regarding landlord tenancy arrangements and to report taxes on them for excise tax and TAT purposes. So that requirement already exists. The additional reporting may be what you're referring to, such as filling out an annual declaration. And that does require a minimal amount of time, just as for having a car every other year or whatever it is, we fill out a renewal there. There potentially could be some, I would think it would be minor cost to a landlord to do some level of additional documentation on this. The advantage to the marketplace is what we're really looking for. And that is, how does this help us with a major crisis that otherwise all of us are paying out of our pocket for and not seeing the solutions that we need? So I think it's a matter of weighing those costs. And I appreciate, Vice Chair, that you brought that up in terms of there's always an equation there, right? And nothing's free. There is no free lunch. There's no free way to our affordable housing solutions. But having a minimal requirement on people to keep the type of documentation that we, in all prudence, should be keeping for tax purposes anyway, just doesn't seem to me to be a particularly heavy onus on landlords.
Well, I don't think it's entirely accurate that there's a lease requirement. I mean, there's oral leases all the time. I mean, that's, that we encounter those all the time, at least in my profession. We have oral residential leases that are commonly month to month, and they often have to go to court to resolve those terms, but it's not as if there is an automatic requirement that documentation, the parties have to keep this documentation down. But if this bill were enacted, that would certainly impose a higher cost for lack of documentation. I think
believe
I
that
mean,
Go ahead.
may I just ask on it, would the declaration forms that we're asking, I mean, that's there's some work that needs to be done, but the idea was to make that as smooth as possible. That in and of itself would be based on the declaration of the landlord, right? What would they need to back up that declaration?
Mm-hmm. Like if you were to do some sort of random audit, which I assume is the practice for any declaration, right? Like, for tax purposes, right? Audited randomly, and they can ask for all my files and paperwork to prove whatever I said on my taxes. Wouldn't a landlord need some sort of form for that? I mean, some sort of paperwork? Even if you started with an oral lease agreement, you would then, what would you produce if you were to be audited on your reported income for rental property?
you'd produce the receipts and you'd produce the bank deposit slips, the checks. If it was in cash, you would produce statements from the tenant. Any of that would be acceptable, but it wouldn't be like you're required to produce a lease in that instance.
So if I'm a landlord for a loan from a bank or something like that, and I have to show that I have income from renters, that they wouldn't ask for a lease agreement.
Yeah, but that's different. I mean, I think that if you're asking for a loan from a bank, you're asking for something in return. You're asking for a benefit. You're not entitled to that loan. You have to provide things. In this instance, you're going to be essentially taxing all residential landlords unless they can prove that they're renting out that land to a short-term, to a tenant in this instance. And because they're not entitled to that exemption, that's my concern.
I guess the way that Maui's thinking about it is that the benefit you're asking for is for this low tax rate, which apparently they've lowered it even a little bit lower than it was before if you do have a long-term renter. So I think that's the benefit you're asking for, right?
Sure. When you're talking about an exemption, that would be the case. But and the current proposed empty homes tax, that it's a supplemental tax, right? It's an additional tax. It's not like you're entitled to an exemption from that. It's just imposed on top of whatever else you owe.
So essentially, you're proving that your house is not empty to avoid that empty homes tax, basically.
Right. You have to document as a residential landlord that you are renting out your residential property, and
Right.
the cost of proving that require A, documentation, B, reviewing the declaration before you submit it. And then when you have those costs as a landlord, I think it's logical to assume that those are passed on to tenants. So I think that's my concern, is that if you impose these compliance costs, that and in our aim of reaching more affordable housing, the existing tenants are going to have to deal with these higher costs when they're passed on to them.
Our subcommittee's recommendation, in the declaration right now is just requiring the property owner, if they're a long-term renter, to say how many months it was being rented out, the amount of the rent, and most importantly, their general excise license number. So that's not anything that, if they're paying tax on that rental income, they're probably going to be pretty good.
I mean,
Yeah,
unless they're not reporting the income, and then that's a whole nother problem anyway.
I'm sorry, did somebody else have something to say to add to that?
Yeah, so I think the idea for our proposal was to have a fairly low proof bar per se. I mean, there's different degrees of proof of things, right? And if you're going to have an audit, that's like a high degree of proof necessary. So I think what we've been trying to find is a relatively low bar for the actual forms to prove stuff, but really it's a declaration, right? It's on the owner of the property to declare this, and I think we provide for funding to allow for some kind of compliance checks going forward, building capacity at RPAD to actually check on this stuff. But yeah, I mean, as with anything, you definitely take your point that you should weigh the compliance costs against the benefits that you're seeking.
I get that the declaration is intended to be a low bar of compliance for taxpayers, but as an attorney, if the landlord comes to me and says, I have this declaration that I'm being asked to sign, my advice to them is don't sign it unless you can prove it.
Mm-hmm.
Don't sign anything unless you can document it under it. Because if they sign something and if they get audited 8 months down the line and they say, well, I didn't have the documentation, I just signed the declaration and I could prove it afterwards, we're going to ask them, okay, where is your lease? Where is the agreement that you had with this person? Where are these documents that you said that you would be able to rely on? But 8 months ago, they weren't preparing that. They were just signing the declaration. I get the declaration as a low bar, but the requirement for additional documentation down the line, it's still necessary. I mean, unless we're asking landlords to just sign the declaration and to come up with the documents whenever they become audited, I think that's just imprudent.
Well, I think it's imprudent not to have proof that you're in documentation. I mean, so maybe we're actually by providing this, we're actually helping people to have this proof. I mean, we could also see it that way. And again, I think the cost is pretty low.
What
you're asking?
I guess, or to the lawyers on the call, isn't it good practice to have some sort of documentation in general, just in terms of landlord-tenant relationships? I mean, my understanding is that it's good to have some kind of documentation just so that both parties are clear on what is expected and what's agreed on. And that if anything, if that's not happening, it would be good to encourage that practice because I think that's kind of the whole point, right? Of these, landlord, I see that as good practice for landlord-tenant relationships in general. I certainly would not want to be renting property and not have any sort of written documentation.
It's certainly good practice, but good practice isn't cheap. That's the thing. I mean, it costs money to document things, and what this bill won't affect landlords who can pay these costs of compliance. A corporate landlord or a landlord who can afford an attorney is not going to worry about this. Who is going to be affected is maybe the family property who's managed by the grandma and grandpa who don't have a written lease set up with their family members that they rent their property to, but they're going to have to document it down the line, and they may or may not be able to afford. They may have a family attorney on their side or on call, but odds are they won't. And those are the persons who are going to be affected by this documentation requirement, not those who can afford best practices. It's those who, it's a laypersons, those who don't have attorneys at their side all the time they enter into a lease.
And it seems to me that if I'm a landlord, I have to file a federal tax return and a state tax return, and probably I guess it's on schedule E. And I have to have records, all those records, so that I can file my income tax returns. So we're not putting any additional burden on them because all those records should be kept by even grandma and grandpa still have to file tax returns.
Yeah, but what if grandma and grandpa aren't charging rent to their kids?
Well, then that's another. Isn't that another? I mean, that's a gift to their kids. Then.
Yeah, that's not renting.
That's a gift, right?
We're talking about long-term
so
rent.
in some ways, we're actually helping mom and pops, by, requiring some kind of documentation of an arrangement that should be documented, that they need to have proof of.
I just think that it's a little presumptive and precocious to think that we know what's best for a landlord, to tell them that you have to document your transactions with your family members or whoever it may be. You have to keep all of these documents on track. I mean, paying your taxes is one thing. Being able to prove where if you received income, if you received a check, if you received this, that's entirely different from documenting the nature of how you and another person agree on how to use a piece of land.
Wait a minute. We require documentation for how you use a piece of land all the time. I mean, if I have a short-term rental, I need documentation of that. If I'm going to decide to put a hotel in my land, I don't understand this. I think it's really the exception to the rule that you wouldn't have to document how you're using some piece of land. I mean, from A to Z, you have to document and get approved for what you want to do, whether, I don't know, ag or renting out or a hotel or whatever, right?
Yeah, but this isn't about a high return use like a hotel. This isn't a commercial use. This is a residential lease. This is something that's, fairly accessible to those who don't have attorneys and to to the laypersons in our state. I think this is not, something you document for a bank loan. This is something that can really be done. A lot of times it is done, whether or not it's prudent, but on a handshake agreement.
Well, maybe
Commissioner
Maui, how
Pham,
because I'm sure questions must have come up in the Maui Council when they were determining how to structure this.
Yeah, I think this is a great conversation. Commissioner Pham, you wanted to say something.
So in our report, in the subcommittee's report on the matter, we wrote about the different exemptions and the declaration form. And as has already been stated in this discussion, the declaration itself is supposed to be a low bar. And then further in the appendix, which contains the draft bill that's going to go in with the report of what that might look like. One of the things that goes in there under administration is how to assist with audits and investigations. And it's very deliberate that the word may is being used. So ultimately, it's going to be an administrative issue as to how they can go about verifying some of these claims. Like it may be tenancy agreements, it may be occupancy agreements. Yes, right now, and what is included in this interim report doesn't include something like a sworn affidavit. Because I think that when it's this problem of having a very specific instance of like a family member just allowing another family member to use a piece of real property to reside in without any kind of occupancy agreement, I think that is something that would be exempt, and maybe we can encourage the city council to find a more deliberate way to include an exemption or in the exemption language or the procedures of how to investigate and audit to allow for something like that if there isn't a written agreement, so that at least there is some sort of sworn declaration, not just the sworn declaration that we've suggested here of initially putting who's renting and how much and reporting your tax identification number. But in administering this, you might expect in the auditing situation that the auditor could investigate by interviewing the reported tenant, and they could clearly come to an understanding that the tenant is a family member and there's an agreement that they are occupying it without having to pay, without a written agreement. I think that's reasonable, and I think that's an administrative issue that would be sorted out. I don't think that it's something that isn't being addressed with the bill that's being suggested or in our report. I think our report is thorough enough on showing what kind of exceptions there are. But yes, I don't think we have explicitly stated this example.
Commissioner Pham, if I may, just for the commission's edification, specifically to Appendix B, page 3 of the report, there under the listed exemptions provided, subsection 2, I believe, as you pointed out, the language regarding this hanai or gifting to the kids or whoever you want on your property, I believe there is language included already. It says the residential property is the principal residence of a renter or other permitted occupier of the property. So just pointing you to that language to highlight that I believe you have language in there already, but I think your point being the what you do to substantiate that, it's open-ended and it's administrative, but the permitted occupier issue is already explicitly noted.
What page was that again, George?
Sorry, it is on Appendix B, page 3, under Section 8-4 exemptions, and it's specifically Section 2 of the exemption section. So Appendix B, page 3.
Thank you.
Right. I recognize that the exemptions are there. I just respectfully disagree that leaving it to the administrators is going to be sufficient protection for taxpayers if they are audited, or sufficient protection, or sufficient instruction for when they want to document or when they want to ensure compliance with these issues. I think that it's easy to leave these matters to the administrators and say that the city may require these things. But if a taxpayer gets audited, they are going to look to the statute for instruction on how to comply. And there needs to be either firm instruction or firm guidelines for them that they know if they do these things, they can be in compliance. And I don't think that leaving it to the administrators is sufficient for a taxpayer who's going to be hit with a supplemental vacancy tax.
What would your suggestion for how they best show documentation in the event that members staying for free?
Well, I think the current homeowners exemption is the best avenue we have. It fits with our highest and best use structure. I think imposing an actual use provision, whether or not it comes to dedications or exemptions, always imposes documentation requirements. And I don't think that it's efficient or that it is preferable for taxpayers to have a higher burden of compliance. Our tax system is complex enough as it is. My concern here is that it's a complex supplemental tax, and that it imposes compliance requirements that are also complex. And I don't think I have a better solution for imposing, another actual use provision on top of the highest and best system we have in place.
So what do homeowners?
Ms. Carson, you have a comment or a question?
I do, thank you. I'm no longer licensed counsel, but during the 30 years or so I was licensed counsel here in Hawaii, the people that I would see, and myself included, that got involved in rental transactions typically just use the 1 or 2 page form. It's front to back. That landlords were using without any counsel involved, that spelled out what the rights were of a tenant, and then had the places for the special conditions, the rent and the term, that type of thing. So that it was a 1 page form. And I believe, but I'm not confident, that at the time that had been vetted and approved through somebody like the Board of Realtors or something that made it so that it complied with Hawaii law in regards to all of the recitations of what the tenant rights were and what the landlord rights were. It would be easy in an empty homes tax type thing to specify that a form of that nature would be adequate to prove up the tenancy, for example. And because it's something that's so commonly used in the marketplace without use of counsel, it wouldn't necessarily impose anything different from what I thought most people were doing. My understanding, being in the civil rights field primarily, was that you needed to keep track of every single applicant who tried to rent your place, who you did rent to, and what your terms were, so that you could be able to show that you're not discriminating against certain people. And that type of form was used just to help solidify a relationship. Something like that could also be created for the extended family ohana type situation, which doesn't have a formal rental payment, but where something as a suggested form could be proposed so that people would know that if they wanted to sign that type of form and use that type of form, then it would meet the criteria of it'd be prima facie evidence of compliance with documentation, for example. And that's been done in several of our rules and regulations to give specific forms that the public can use so that people don't need to feel that they need to consult counsel for every single transaction.
Okay, thank you. Thank you so much. I think we've had adequate discussion on this subject. I mean, I would just say that, you know, of course there are going to be costs for things. I think we've intentionally, through this report, an interim report, addressed those and tried to make this as low a bar as possible, with as low compliance costs as possible, relative to the very significant benefits that we see coming from implementing an empty homes tax. Again, addressing, you know, housing affordability, affordable housing supply, and you know, encouraging more productive investment in real estate, as well as a revenue source for the city and county of Honolulu to cover administrative costs and then some. So anyway, I believe we've sort of bled into discussion. So I think does anyone have anything else to add on this subject, or should we move on to our formal discussion segment of the agenda? Okay. Turning now to the discussion and action upon the Commission's interim report to Council dated today, December 29th, 2021. Can you all hear me? I'm seeing some networking issues.
We can hear you. Your video is at least for me, not on, but we can hear you loud and clear.
Okay, thank you. Following our last meeting on December 20th, only a handful of revisions were made to this report, including summary conclusions were inserted for sections 1 and 2. No substantive changes were made to section 1 of the report. In section 2 of the report recommending the empty homes proposal, comments were inserted on page 5, paragraph 2, regarding recently introduced Bill 49 related to empty homes and Bill 76, 2020. Updated data and figures were inserted on page 6, paragraph 1, related to Oahu's vacancy rate and property valuation. And additional comments were inserted pursuant to the Commission's discussion at the last meeting regarding the balancing of anticipated costs upon the city and taxpayers, as well as addressing the benefit of technological investment and upgrades to the existing paper-based system on page 12. So I think in that last item, I think we were just, you know, having a very robust discussion of part of that last item that we added in, which was this weighing of costs against benefits of proposing the bill. And in addition, we added a brief conclusion to the interim report on page 15. Members, I would like to open the floor now for discussion on the revised interim report. As a reminder, we are not bound to the finalized draft before you. Should members of the commission suggest and then approve by majority vote as a body any additional changes, edits, or corrections, we can do that. Once all members have had an opportunity to share their thoughts and any additional suggestions, I will then ask for a motion to approve and adopt the interim report and its recommendations so it can be transmitted to council. So I now open the floor to further discussion. Vice Chair Wong.
Looking on page 12 of the interim report and subsection 8, the second paragraph, I appreciate the insertion of the portion of this paragraph that reflects our discussions at our previous meeting, but I was under the impression that it was to be added to section C. So starting from, I guess, the second paragraph, starting with the commission. The commission believes it is reasonable to assume the empty homes proposal would result in additional costs for the city to administer the tax, additional costs for property taxpayers, period. Property taxpayers, even if ultimately exempt from the tax, may incur legal fees for professional services in the filing, declaring, appealing, or otherwise responding to this new empty homes tax, period. The commission also believes these costs should be weighed against the benefits the tax would have on the local rental and for sale real estate market, period. I think this is better suited for insertion in section C right below under the reality of implementing an empty homes tax. I think that was what our discussions reflected in the last meeting. I just propose that we move that portion to section C, following either the first paragraph or the final paragraph in that section.
So you're moving, do we need to move to make that edit, or can we just sort of edit on the fly, Commissioner White?
I'm making note of what Vice Chair has suggested and making note of that. When the formal motions is made regarding the interim report, I will provide the phrasing for each suggested change so that it can be fluid. But at this point, my understanding of Vice Chair Wong's, if he wants to make a motion, he can now, but it would be to amend page 12 of the report, paragraph 2 under section 8. And Vice Chair Wong, if I can just confirm, is it the entire paragraph or ending at and for sale real estate market?
Correct, and ending at for sale real estate market.
Okay, and Vice Chair Wong's suggestion or move is to move that down to subsection C below the first paragraph on page 12. Is that correct?
That is correct.
If there's a motion, I would second that motion.
Yeah, so
but we can also do it at the end if we want. I second the motion on that amendment. I agree with that amendment.
I don't think it needs to go after the first paragraph, because that second paragraph, like it leads right into describing the timeline. So I think it should just be the first paragraph of that section.
Okay.
I'm amenable to that. I agree.
Okay, so Vice Chair Wong is amenable to Commissioner Pham's proposal to amend his proposed amendment. And to be clear, it is paragraph 2 on page 12 from the commission believes through for sale real estate market, that chunk of that paragraph will be moved to the first paragraph of subsection C on page 12. Okay, and
Agreed.
that is moved and agreed to by Vice Chair Wong and seconded, I believe, by Chair Mould. And Chair, if you would want to ask for unanimous consent.
If there's unanimous, if there's no objection, we have unanimous consent. And I get so ordered or so moved. Yes.
Yes.
Thank you. What is the language I use there?
Yep, you're good.
Excellent. I think that's a good catch. Commissioner Pham.
In that second paragraph of section 8, later in the paragraph, not the part that got edited out just now, I just see a typo portion of the empty homes tax. It's missing a T.
Yeah.
Is that just a clerical thing, Commissioner?
Yeah, we can put that in.
Correct.
We don't need to move on that one.
Technical, yeah.
Thanks.
Wait, I think Commissioner Stormo Gibson was objecting, but all technical stuff, if you just let me know, I can fix it all. Anything non-substantive is no need to move for anything.
We are open for further discussion.
Do we have any way to, and this might not be for this report, but for perhaps the final report, to do some revenue projection?
I think we have leeway, absolutely, to do that. Would be my call, subject to confirmation from Commissioner White. I mean, we have discretion in our final report to talk about anything, even if it's a addition or clarification or to this interim report. I think we have leeway to do that.
Yes, absolutely. To confirm Commissioner Stormo Gibson's question regarding revenue projections, I believe we have made efforts with RPAD to do certain things, but I believe if we're able to, I think the Commission had previously discussed looking into the academic world experts that you have at your disposal to possibly crunch numbers as well, and that would not be a problem in any respect to supplement your thoughts. And even if the interim report or matters related to it are brought before the council, the Commission can testify or agree to testify regarding certain matters that are complementary to the interim report.
Okay, so I'm just thinking, really to weigh cost versus benefit, it'd be great to have some, revenue projections, right? And if it sounds, if I'm hearing correctly, get them from RPAD, that's great, but we're not also, it can be okay to get them from other sources. If we would like to put forward, hey, based on, I mean, it is public information. Like, you can go online and see what everybody paid for their property taxes last year, right?
So Commissioner Stormo Gibson, the expert testifier, Philip Garbodin from University of Hawaii, has indicated an interest in doing just such an analysis for us.
Okay, great. Okay, yeah, I didn't know that, but I think that would be great to include in the final report, so that decision, can weigh things, right?
Yeah, I mean, I think it's really, to your point, I think it's very important for council in particular to take those into consideration. And I think that's, part of our recommendation in the report is that they do so.
Great. I'm happy to hear that.
And to respond, this Commissioner Pham, the section 7 speaks to the revenue matter and speaks to the attempt to establish a revenue projection, especially with the drafting of Appendix B, like an actual bill that looks different than the one that was previously discussed, Bill 76. I think if you had something like that actually in the hands of the city council, and it was something that was drafted. You could use that to set your parameters to set up such a projection, but without understanding the rules on exemptions and what that might actually look like, it's hard to come up with a good estimate. And we also speak to what kinds of data we have already been able to accumulate there. And we looked at the census data and saw a 9.2% vacancy rate. But exactly the methods on how you would take the existing real property data of the city and county and turn that into a revenue projection. I'm assuming there would be multiple models and different analyses that go into a conservative versus a very aggressive outlook on how many people would just pay the tax versus how many people would change how they use the property. Those assumptions, perhaps the academic view would be useful, and that's something that we as a subcommittee just didn't have the capacity to do ourselves.
Mm-hmm.
And of course, you'd have to weigh that revenue projection against other benefits, right? Such as increased housing supply, maybe, taking pressure off of the skyrocketing, market prices right now, and things like that. And that's where some of the more academic third-party analysis would be interesting and important for decision makers to hear. But the revenue to city is certainly part of this.
So I think to the point of issuing this interim report and having that appendix, we as a commission could have something to really stand on and say, this is actually the report, we're serious about this, here are the parameters that we set out in Appendix B with the draft bill. And that can be used for the purposes of conducting a revenue projection, a forecast, a model of some kind.
Great.
And I think some folks on this commission would be able to be involved in that analysis as well, and probably be able to help out and offer their assistance in any kind of analysis, I would guess.
Yeah, well, and that, again, Maui County is trying to get good. It could be interesting to see what percentage their housing stock are. Because to my knowledge, starting next year, they will have the most accurate information in the county on that. Now, of course, the county is different, so yeah, you have to go to data as well. But anyway, whatever progress we're able to make along those lines, I think will be helpful.
I have some additional comments on page 5 of the report. I think that the heading is a little too strongly worded. The recommendation to enact a supplemental property tax on empty homes. I think the recommendation is on a supplemental property tax, because I think that the commission was in agreement that the homes proposed was preferable to current bills that are in front of the city council right now. I don't recall having a unanimous consent on whether or not the city council should enact the bill as structured. In fact, I remember Commissioner Legal and I both had concerns in our last meeting. So I respectfully ask that we dial back the heading language just to say recommendation on a supplemental property tax instead of recommendation to enact. And then in the second paragraph of that section, preceding the commission, to lead off with, if the city intends to enact a vacancy tax, the commission recommends, and then to proceed with the sentence as structured. I just don't see language in the rest of the section that justifies such a strong recommendation in either the heading or in that second paragraph. because I think that we're all in agreement that it's preferable to the current bills, but I think the costs and benefits are something that we've asked that the council evaluate rather than us. So leaving it to the council, I think we're in a better place as an advisory commission rather than an advocacy commission here.
So if I may interject, Vice Chair Wong, to clarify, if I am hearing you correctly, are you motioning for on page 5 of the interim report that the subject or section 2 header be amended to say recommendation on a supplemental property tax, striking to enact, and in paragraph 2 of section 2 on page 5, the prefatory phrasing include if the city intends to enact, or city council, if you could clarify, intends to enact a vacancy tax, comma, the commission, and proceed with paragraph 2. Is that the two correct edits that you are proposing?
That is correct. That accurately reflects my motion.
And is it the city you wish to be, if the city intends as a whole body?
Yes.
Okay. So Chair Mold, Vice Chair Wong has made a motion to amend the interim report with the 2 changes as noted.
I think the title change is a good modification. The second paragraph, the way that that sentence reads, to me, it reads clear that the commission recommends the city council forego further consideration of Bill 76, period. Well, not period, by saying that it's not if the city is going to recommend a vacant homes tax or an empty homes tax, we recommend against Bill 76 and in favor. We are recommending that Bill 76 is no longer for further consideration and in favor of introduction and consideration of this empty homes proposal. I think that sentence already makes that statement as it's written.
I agree. Explained that way, I agree with Commissioner Pham. So,
okay.
Yep.
So
I think it's just the header change that.
As a
Chair,
matter of record,
muted. I see your mouth moving.
Okay, as a matter of record, Chair Mold, did you hear everything there?
I did, yes.
Okay, so
Sorry,
Vice Chair.
I prompted a second before Commissioner Pham came on, FYI. So,
So I believe Vice Chair Pham, or not Vice Chair, Commissioner Pham has moved to amend the proposal by Vice Chair Wong. Vice Chair Wong is amenable to that amendment. So Commissioner Pham's motion to amend will be considered a second.
can I ask a question? Can I query this a bit before we move on this?
Feel free.
So I feel like taking out enact is really changing and watering down the spirit of our recommendation. I would be willing to consider a different word other than enact. But what if we were to say something, seriously consider enacting in the title?
I think that is a bit too strong. I think that recommendation on vacancy taxes within the scope of the commission's advisory role. I think that best reflects our role here as commissioners.
I mean,
yeah, this is just my 2 cents.
But
we understand that, yeah, and you're entitled to your position. We understand that. My position is I think that waters it down too much. I think our proposal is a little bit more intentional than just a recommendation on something. Although maybe the vaguer language leaves it open to be as well. And I'm curious to hear other commissioners' thoughts on this.
I would just say that, you know, I guess I could go either way. Recommendation on a supplemental property tax, but ultimately the recommendation is to go with the proposal in Appendix B. You know, and I would say that we also recommend greater transparency. We don't say, you know, we recommend that you consider greater transparency in, you know, with the public. We recommend greater transparency. So I do think we are making recommendations on things, which is why we are, you know, a commission. But really, in terms of the phrasing, I think either way, that section reads as saying, hey, we have an empty homes proposal, and you should really, you know, we recommend that.
Yeah, I can go either way. To me, it's just semantics. It's, I mean, either way, it's not going to change what our recommendation is. So I'm fine either way.
I'm fine either way on the header, and I think whenever we go back to the first meeting of the commission and Council Chair Waters spoke, this was one of the things that was spoken about very deliberately for us to even look at. So I think it's clear that City Council is interested in what this commission has to put forward on the issue. So that's part of the reason why I don't want to worry about the to enact. I think the City Council has expressed a seriousness about the empty homes tax, and I think that our recommendation to stop considering Bill 76 and to consider this instead is strong.
Okay, I think I'm amenable to the edit as well. I mean, I think it's, you know, and I see how I see how Vice Chair Wong can see that it's sort of too strong and too pointed as well. So it really is in City Council's discretion. So this is our recommendation. I move to second.
Okay, there's been a second, and to be clear, that is to the amended recommendation of or movement of Vice Chair Wong to only amend the subject heading of section 2 to remove the words to enact and replace them with recommendation on, actually replacing to enact with on. That's the extent of the motion, and there is a second.
There being
Chair,
no,
yes.
there being no objections to the motion, is there unanimous consent? There
Yes,
being no
Chair.
objections, the motion is moved, is adopted.
All right. If there's no
Okay,
further,
so
I've got one more minor edit. I'm sorry. I'm a
no worries.
broken record at this point. This goes to section 1. So this goes to the valuation section on page 3 of the interim report. Looking at the first paragraph at the top of page 3. I'm sorry I didn't catch this earlier, but I think it's important given the presence in both the prior commission's report and our current request to RPAD. I think that sentence starting on page 2 with these recommendations, including providing homeowners a better understanding of how their properties are assessed, sample documents, and basic layman information regarding the assessment process. I'd like to add the city's use of the Marshall and Swift appraisal system, because that was addressed in the prior commission's work. But I think that it's important to note that we got a non-response when we did ask for information on this again this year, the same way that it happened in 2019. So just adding to the end of that sentence, which sort of straddles pages 2 and 3. After process.
So this is the first incomplete. It's like the crossover paragraph.
That's correct.
Yep.
So it would read, these recommendations including providing homeowners a better understanding of how their properties are assessed, sample documents and basic layman information regarding the assessment process, comma, new comma, insert here, insert, comma, and the city's use of the Marshall and Swift appraisal system, period. And I move to add that language to section 1, subsection A of the interim report.
I second that.
Hold on. Is there unanimous consent?
Chair, if I may, is there any discussion? And I believe that everybody is clear on the Vice Chair Wong. I made note, and I just want to confirm in my notes. The insertion after the assessment process on page 3, second line, comma, and the city's use of Marshall and Swift appraisal system, period.
That is correct.
Okay. So, Chair, if there's any discussion, and then you can move for the question.
Is there any discussion?
I just want to,
agreeable, just because it was mentioned by previous commission, so I just want to keep backing that up.
Commissioner Stormo Gibson.
I think the Marshall and Swift is used to measure the cost portion of the tax, right?
I'm sorry, we kind of lost you there for a second.
Marshall and Swift is used just for the cost, so just for the improvements portion of the tax, right? Not the land portion.
That's correct. All buildings and improvements are valued with the Marshall and Swift system.
Right.
Any further discussion? If no discussion, is there any objection to the motion? And is there unanimous consent? There being
Yes, sir.
unanimous consent, the motion is adopted. Any further discussion or edits from commissioners?
Nothing further.
I think this is, at this point, we should maybe move to adopt the interim report as amended in this meeting. Is that correct, Commissioner Aide-White?
Yes, and if I can, if it's your motion being made, Chair, actually, it may be best for another commissioner to make the motion, but it's a motion to adopt as amended. And the specific amendments as previously discussed are 1, amendment on page 12, moving the second paragraph. 2, on page 5, changing the section heading to remove the language of to enact. And 3, on page 3, the insertion of the Marshall and Swift language as we have discussed, moved, and approved, or as you all have discussed, moved, and approved. So the motion is to approve as amended with those 3, and then if I can just add any technical non-substantive changes that the drafters or commissioners may find.
So moved, Vice Chair Wong.
Second.
And that was Commissioner Pham?
Yes.
Thank you.
Absent objection or request, do we have unanimous consent to adopt and approve as discussed today the Commission's interim report to the Council dated December 29th, 2021.
Yes.
Aye.
Yes.
No objection, unanimous consent.
No objection, unanimous consent. The motion is adopted to recommend our interim report to Council. Nice, kudos, congratulations, Commission. Great work. Thank you so much for your hard work on this. We really appreciate it. And to our stakeholders as well. And Chair Say, please.
Yeah, I just wanted to thank the commissioners for a job well done. The journey isn't over yet, and I think the commissioners have to realize it. My personal thoughts is that your points of views were very much well taken, and the experts that you folks had during this year were excellent. I did get a chance to listen to 2 of your hearings, but more importantly, that this journey starts probably in January, February with the report. And I would hope that all of you would participate in the public hearings that we have on first reading, second reading, third reading, so that you could educate the members of our city council. The idea is great. I didn't want to interject anything else at this point, but questions that I would have posed to also make it look like it was a very comprehensive package was that we'll be facing the short-term vacation rentals. That's another big issue. Personally, I think we'll be facing some shortage of employees at the Department of Budget and Fiscal Services, even though right now, personally, among all of you, I thought it would have been great if someone could have said, hey, can we piggyback this particular provision on the real property tax to the 4 positions that the department just created on the transit accommodations tax? You know, just requesting more and more personnel costs is going to be difficult. And I believe we also saw that bill introduced by one of my fellow council members in regards to appropriating more position counts in addressing our real property tax tier level as far as the computerization. All of this takes money, takes resources. And if we could have comprehensively looked at it from a point of view about this particular measure is going to impact us by, let's say, $250,000, which is what one of my council members had in regards to that. The other one was the upgrade in the technology in Steve Takara's office. And that's another out there issue that we'll be having to address along with the vacant homes, empty home tax, supplemental tax, along with the short-term vacation rentals. Administration will probably be pushing more hard on the short-term vacation rental bill than anything else. So just to be aware that when the bill is introduced in its final form, so I'll get George, Janelle, Melvin, and I to work at it, Ellen, in coming up with a new bill, and the others we could set aside. And I also want to thank Ellen for a job well done in doing that comparative analysis of the 3 bills that is in the hopper right now. So to all of you, it's not over. So the journey just starts at this point with the recommendation of the Task Force Commission's report. And I think we should have a very lively discussion. One thought, Rocky, I haven't seen the draft recommendation proposal, but more importantly, focus it whereby you could get each of your members to highlight different sections of the bill. That will have a tremendous impact. Alvin, you could say a few words on a particular section of the bill that is different from others. Aki, you could do the same thing. Jenna, Mr. Wong, and Rocky, and the other members, to get everyone involved will make it much more easier for council members to appreciate their appointees to the commission. So in closing, thank you very much. The journey's not over. Thank you for the public service that you folks do on behalf of the County of Oahu. And I'll see you folks in January. Aloha.
Aloha. Thank you.
Aloha.
Thank you.
Mahalo, Speaker Say.
You're welcome.
Thank you.
You're welcome.
When is our next meeting? Is this good?
So Seeing there are no more announcements, we can now move to scheduling our next meeting for the new year. Are there any announcements from other members? All right, let's move to scheduling our next meeting. Let's take a look. It'd be nice to have Commissioner Aide White on for this part in particular, because he knows the council schedule. But I don't know if our first meeting is going to have to depend on the council schedule at this phase.
Thank you, Chair. I am here, and I was just pulling up the calendar that was just provided to us recently. So as far as January is concerned, if the commission wishes to meet at some point in January, the 11th, 12th, and 13th are committee meeting dates. The council meeting date is the 26th. The legislature is opening on the 19th. So pretty much the last 2 weeks of January, the 17th to the 21st, the 24th to the 28th are wide open. The 17th is a holiday. That's Monday. It's Martin Luther King Day. The 26th is the only day that would not be a day available. But other than that, it appears to be wide open. My recommendation would be to sway away from the first 2 weeks of January and lean more towards the last 2 weeks of January, just given committee meetings on the 11th, 12th, and 13th.
Yeah, I would propose maybe January 25th at this phase. That's a Tuesday, January 25th. It's the day before City Council. So maybe, it's the day before their main hearing. I mean, if something major comes up in the budget meeting, in the prior committee meeting, we can address it, before. I don't know if there's a utility in addressing it before the larger council meeting or not, but it might be a good time to discuss it. How do you think about the 25th of January?
I won't be available the entire week of the 24th. So if we schedule it then, I ask to be excused.
What about the 18th?
Okay, well, 18th would work for me.
How about the 19th?
19th is fine for me. Either one.
No conflicts with any of those dates.
19th works with me. Let's do it on the 19th. Do we prefer afternoons or mornings? I think afternoons worked for some of the other commissioners better. So why don't we say that 2 o'clock or 3 o'clock time slot on the 19th? Any preference for 2 or 3?
2 o'clock, good.
2 o'clock.
2 o'clock. Okay.
So I have here Wednesday, January 19th at 2 p.m. And just for the commissioner's knowledge, I mentioned, but it may not have come through. I believe my notation indicates the legislature will be opening on the 19th, but I believe most of their activities occur in the morning or around noon time. So if you all had any issues of stuff with the legislature opening up, but I don't even know that the public's going to be invited. But that will be on the morning of the 19th, and the meeting you all have set is Wednesday the 19th at 2 p.m.
I think we can
George,
manage that schedule.
Is in-person available for those of us who prefer in-person?
It most definitely is, of course, pending whatever happens with Omicron and what the mayor or actually the council chair, if he is to make any other decisions. But at this point, it is most definitely available. I will reserve the chambers, and at this point, we presume to operate under the existing rules and orders that we have been operating under.
Great.
Yeah. That's good.
Let's hope Omicron is not so bad that it changes protocols. Okay. So, 2 p.m. January 19th, there will be a physical space made available and, of course, remote access as well. We've decided. There being no further business today, are there any other discussion items for today? There being no further business, is there a motion to adjourn?
Motion to adjourn.
Second.
Was it motion to adjourn by Commissioner, is that Peters or
yeah.
Wong?
Peters,
Second,
and then seconded by Vice Chair Wong.
second by Vice Chair Wong. There being no objections, this meeting is adjourned.
Thank you, everybody.
Happy New Year,
Thanks,
everyone.
everyone. Happy New Year, happy holidays. Really appreciate the lively discussion and the points of view of all of you. Thanks so much. Really great work. I think we've really put something forward.